Hello, this is Attorney Mike Gravel coming to you from Chicago. As usual, I got some good stuff. I got material from two places. Both want to remain anonymous. They don't want their name sullied by Law Talk with Mike. I want to say thank you. You know who you are. You know who you are. Thank you very much. Let's do this thing, shall we?
Sorry about that, everyone. Next matter I have is Suzanne Al-Gassed.
And Your Honor, Ms. Al-Gassed is going to be entering a not guilty plea to this charge.
Thank you. I appreciate that. Ms. Al-Gassed, good morning to you. Ms. Al-Gassed, were you in the courtroom this morning when the video containing your constitutional trial rights was played? I can't hear you. You don't have to do that. Just stand still and get close to the mic. Pull up to the podium. There you go. Did you understand the rights in that video this morning? Did you understand the maximum penalties associated with misdemeanors? I can't hear you, ma'am.
I did.
Did you have sufficient time to speak with your lawyer this morning?
Yes.
Thank you. We're on record in 24 CR 06486. In this case, you were charged with the crime of domestic battery, a first offense alleged to have occurred on May 20th of this year in the area of 1755 East 4th Street. Do you understand that charge?
Yes.
How do you wish to plead to that charge?
Guilty.
Say not guilty, you say?
Yes.
I'll accept your plea of not guilty. I will inform everyone that I have reviewed this matter for probable cause. I do find that probable cause does exist to support the charge of domestic battery and Ms. Al-Gassed's custody status. I will appoint counsel to represent Ms. Al-Gassed, and let's get you a pretrial setting, then we'll go over your custody status.
That'll be July 11th at 8 a.m.
Thank you. July 11th, 8 o'clock in the morning is your pretrial conference on this case. Ms. Al-Gassed, you will have an attorney representing you. Now we're going to go to your custody status. Ms. Giannoli, what would the city like to offer?
Thank you, Your Honor. Here it appears that the parties were in a dating relationship. The two were sleeping on the sidewalk when the defendant started yelling at the alleged victim and began punching him in the face.
Exciting and new.
Second witness, who does not know the parties, who also corroborated the victim's statement indicating that he had been punched in the face. Her criminal history is of concern to the city judge. It's 21 pages in length. It consists of multiple crimes of violence as well as multiple failures to appear, and it spans over two different states, both California and Nevada. By way of example, Judge, she has a 2021 battery conviction, a 2006 domestic battery that was a decline, a 2014 child cruelty for which there's no disposition. She has probation violations from 2016, 3 probation violations from 2017, multiple failures to appear in 2020. She has a battery-related charge with no disposition in 2020. Again, multiple failures to appear in another state in 2021. Several failures to appear in another state in 2023. Another battery from 2021 for which she was pled or found guilty. And several more failures to appear in 2022. Your Honor, given the crimes of violence...
That really sucks. I mean, really.
To appear in probation violations, we also believe that she is a likely flight risk or a likelihood to not comport with court process. Given all this, Judge, I'm asking you to impose $5,000 bondable. Should she be released, I'm asking for conditions that she obey all laws, consume no drugs or alcohol, and have absolutely no contact with the alleged victim in this case, please.
All right. Thank you, Ms. Giannoli. Mr. Edgerton, what would you like to offer, please?
Your Honor, on behalf of Ms. Al-Gassed, she represents that she is employed at a smoke shop and that she has an apartment that will become available to her on the 1st of July. Until then, she has a bed.
Okay, by smoke shop, do they mean like a marijuana store? Because I can't imagine a worse idea than this woman working at a marijuana store.
At the CARES campus. And so under those circumstances, she would request an OR release. With regard to the information the city put on the record, we would ask the court to find the city has not carried its burden and that an OR release is appropriate in this case, that she can be monitored through supervision and testing to ensure safety community. Thank you.
Thank you, Mr. Edgerton. Ms. Al-Gassed, is there anything you wish to say with regard to your custody status not related to the facts of the case, please? You're not required to say anything.
I mean, so I can go to work. I will not disobey any rulings.
I find that the city has easily met their burden showing by clear and convincing evidence the need for bail that non-monetary conditions in themselves will not suffice. The least restrictive means at ensuring Ms. Al-Gassed's presence at court is indeed bail. The bail will be $3,000 and it'll be cash only based on that failure to appear history, which concerns this court greatly about you actually appearing for this case. If you're able to make that bail, you will obey the following conditions. Obey all laws. You will consume no alcohol or drugs without a prescription. I'm placing you on enhanced supervision. So if you're able to make that bail, you will report on release to sign up for enhanced supervision. I'm employing that condition because of subsection 9 indicating substance use in the past 10 years. That's a 2 on subsection 9. And finally, you will have no contact with a Nathaniel Witt. I want you to know that a violation of that pretrial no contact order is both contempt of court and a new misdemeanor crime. Do you understand that?
Yes.
Thank you.
And Judge, anything we want to do with the revo or?
Oh, no, not at all. Thank you. That case stays open to be handled by the trial judge on the other matter.
Thank you.
Jared Hames is next on our calendar. Mr. Hames, good morning.
Good morning, sir.
All right, we're back on record with Mr. Hames. Mr. Hames and I were with each other yesterday, where Mr. Hames entered a no contest plea to a trespassing case in 24 CR 06329. We continued this case in order to allow the city to contact the victim to see if that...
The facts of this are creepy as it gets. And this guy looks like Jack and the Beanstalk or something. I don't know. He looks like a character.
person wished to be here. Ms. Giannoli, has the city attempted to contact the victim?
We have attempted to contact the victim, Your Honor. Unfortunately, his voicemail box was full, so we were unable to make contact. We are prepared to proceed today.
Please go ahead.
Thank you. Your Honor, law enforcement responded to a reported burglary. When they arrived on scene, they saw the victim and the defendant outside. The two of them engaged in a verbal altercation. The victim indicated that the defendant had entered his residence. Law enforcement had also spoke to the victim's girlfriend, who indicated that the defendant had been following her home. She ran up to her room. He followed her and he began knocking on her door after she had locked it, and she told him to leave multiple times. However, he did not, despite her commands to leave. His criminal history is concerning, Judge, is 32 pages in length. I find this case not to be on the spectrum of typical trespassings that occur in commercial premises, but far more aggravated in that it occurred in a residence and was fairly concerning to both the victim and his girlfriend, Judge. Given that, I believe jail is appropriate in this case. I'm asking for 45 days, please.
Thank you. Mr. Edgerton.
Your Honor, this was a situation in which Mr. Hames had become intoxicated and basically had lost his tether to reality, and so his conduct is best understood in that context. Our request is for him to be sentenced to credit for time served. He's been in custody for going on 6 days now. If the court finds that unacceptable, then I think a better solution is to order him to obtain some level of treatment and to give a suspended sentence to ensure his compliance.
Thank you. Mr. Hames, is there anything you wish to say, sir, before I sentence you? You're not required to say anything, but you're welcome to.
No, Your Honor.
All right, thank you. Just one.
I mean, that guy does not look like he's all there to me. That affect is scary.
Second, please. These facts are concerning, Mr. Hames, I got to tell you. And, you know, we can chalk this up to you being intoxicated, but that only goes so far. At some point, you have to face the consequences of this behavior, which were alarming, frankly. I would have great concerns if these facts happen to me. I'd be here asking for you to do some jail time. Here's the sentence. And by the way, I'm looking at your criminal history,
Right.
which is significant. It's significant. I'm going to go through it a little bit. First of all, there are FTAs in your past and criminal contempt. I have concerns already placing you on just a suspended sentence without any other conditions. Another FTA after bail. Criminal contempt in 2021. Use, possession of drug paraphernalia. 2009, an arrest for possession of dangerous weapon and a domestic battery by strangulation. You pled guilty to domestic battery second in that case. And then we're going back in time again. So here's what I'm going to do. 179 days in the Washoe County Jail. I'll suspend all but 60 days. You will serve 60 days in jail on this. Like I said, I've considered these facts aggravated. The rest of that suspended sentence will be suspended for 2 years. You will obey all laws. You will consume no alcohol or drugs without a prescription. You will stay away from this residence. 346 Mill Street. And you will have no contact with Dane Beers.
Yes, Your Honor.
That'll be my order. Thank you, sir. Good luck.
Hispanic females that attempted to hold the door closed to prevent the driver from exiting the vehicle, stating that they were scared for their safety. Officer observed on scene for the defendant to have red glassy eyes and swaying. Defendant admitted to having drunk half a gallon of vodka before driving.
Half a gallon of
Or
vodka.
half of a half gallon, sorry, it's half of a half gallon of vodka. 6'8" GN, 5 walk and turn, 3 1 leg stand. DIC was ready, consented to.
Okay, I was gifted this this bit here. I did a little bit from this yesterday, but there's some gold on here.
Breath rate below 0.121 and 0.120.
Do you mind looking to see if he has any prior DWIs, Mr. Ken?
He does not.
Okay, Mr. Torres, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, you'll go to jail. You will not get any more PR bonds. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
We will check, but I will allow you to drive while you have both. I'm going to have you go to Victoria. We will have you sign a reset. We're going to get you out of here to hire a lawyer. After that, you'll get with Mr. Garcia for your bond conditions. After that, you'll be free to go. Do not pick up any new cases. And I would get on finding a lawyer quick if you like your driver's license. Do you understand? Please. Frederck Conway.
Yes, sir.
Good morning, sir.
Good morning.
All right. Sir, you were charged with assault of a family member. You're also charged with criminal mischief. You're facing up to a year in jail on each of those cases. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay.
May 15th, sorry, it's TBD. On May 15th, officer dispatched for a disturbance. The complainant stated that the now defendant was destroying his store and beating his wife. Upon arrival at the location, officers observed the defendant with no shirt, sweating profusely and under the influence of something due to his manic behavior and his inability to follow directions from officers. Instructed the defendant to stand up and place his hands behind his back. He ignored the instructions, began to count his money inside his pockets, then dropped his money and went to go pick it up. After securing the defendant, the second complainant, Crystal Jett, stated the defendant is her husband, who she lives with and been married to for 14 years, stated that they had an abusive relationship in the past. But on this date, the defendant asked this complainant where her gun was, and the complainant told the defendant that it was at their house, but they could not find it at the home, and that's when the defendant walked outside in the middle of the street and punched her in the face with a closed fist and then kicked her. The complainant could not tell officers where she was kicked because she could not remember, but the defendant continued to assault the complainant by biting her on the left cheek with enough force to leave visible teeth marks, and that this assault caused her pain. She did state that she did not want to press charges because she is afraid of the defendant retaliating against her. The first complainant regarding the store stated that he used both of his hands and aggressively pushed the front entrance doors with enough force to crack the glass door, worth $1,000 in damage, and would like to press charges for the criminal mischief. And due to that fact, he's been charged with AFM and criminal mischief class A.
Got it. Mr. Conway, I'm going to find that there's probable cause to go forward with your case. On your assault case, a protective order was issued on the 14th of this month. I would suggest that you get to know it. If you do something to violate the protective order, the state can and will file a violation of a protective order against you. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on that, I can hold you at no bond, zero bond, and I'll do it in a heartbeat to protect the public. I'll do everything in my power to protect the public. And if that means locking you up, I'll do it in a heartbeat, Mr. Conway. You understand?
Yes, sir.
No contact with the complaining witness, no weapons, and I'm also ordering you not to go back to the location where this happened.
Yes, sir.
Where was this, Mr. Kim? The actual mischief?
The mischief was at. Oh, 7302 Hurricane Forest, which is C&T Grocery. It looks like to be just a side road, not quite a gas station, but just one convenience store.
All right, no more acting, no more P. Diddy. You understand?
Yes, sir.
All right, we're gonna reset your case to give you time to hire a lawyer. I'm first gonna have you go to Victoria, sign a reset. After that, I'm gonna have you take your seat in the jury box while we get your bond conditions, while you sign it. After that, you'll be free to go, sir.
Yes, sir.
Come on.
Oh, yes. Oh, yes. He told the defendant, no more P. Diddy with a bow tie on.
Is that gonna be bond conditions on both cases or just the one?
Wait, hold on a second. You said something about dope or alcohol.
They believe he was under the influence of something due to his manic behavior and inability to follow directions.
Okay.
He didn't articulate the drugs.
So I'm also ordering you no dope, no alcohol. I'm gonna randomly test you, Mr. Conway. No using anything. Okay. Now it'll be with Mr. Garcia. Good morning, Mr. Selenas. Sir, you're charged with two cases. You're charged with possession of marijuana. You're also charged with possession of a controlled substance. You're facing up to a year in jail on the possession of a controlled substance. You're facing up to 6 months in jail on the weed case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 23rd, 2024, a traffic stop was conducted in a vehicle to failing to stop at a designated point and failed to turn in the first available lane. This now defendant was in the front passenger seat of the vehicle where a backpack was found on the floorboards. And inside the backpack were two scales, 17.14 grams of marijuana and 1.85 grams of Xanax. And due to that fact, has been charged with PCS and possession of marijuana. For the other co-defendants, there was a black pistol on the back right passenger seat, a 1.42 grams of meth on the back left passenger seat, and for the Xanax, this now defendant did not have a prescription for these pills at the time of the arrest.
So they charged the co-defendant, correct?
Yes, Judge, but let me, Marquise Elridge and Javon Johnson were charged with unlawful carrying of a weapon and PCS.
Two.
Yes, Judge.
Okay. Mr. Selenas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using any kind of dope, I'll put you in jail. You will not get any more PR bonds. You understand?
Sir.
I'm also ordering you not to hang around and not to be with the other two co-defendants in this case. If I find that you're hanging out with them or talking with them, anything, likewise, I'll put you in jail.
Sir.
What do you do for a living?
All right, now I'm looking for a job as it came home.
How old are you?
20.
Did you graduate high school?
No.
Why not?
Marquise Elridge?
What's that?
I was in the streets.
You don't have any folks around.
Kind of.
What's kind of mean?
Yeah, but not really. Really just got myself. But I'm trying though.
No. I want to know, why are they not around? You don't get along with them?
Yeah. Yes, yeah.
Is it the lifestyle?
Yes, sir.
Mr. Selenas, it's going to catch up to you. And I'm telling you, you're going to end up nowhere good.
Yes, sir.
Who's around? Mom and dad or who?
My mama. I don't know my dad. Dad in jail thing.
He's in jail now. The apple doesn't fall far from the tree. Is he in prison?
Yes, sir.
You seen him in prison?
Yes, sir.
How does he tell you it is?
I don't want to beat up.
Say it again.
I don't want to beat up. That's what you say. You don't want to beat up.
Yet you're continuing to go into his footsteps. I'm telling you, when you hang around with dogs, you get fleas, man.
Yeah.
This. At some point, you're going to be told to do something where you've dug yourself a hole you'll never get out of, man. I want you to get your high school diploma. I am now making that a condition of your bond. If you don't, I'm going to make you do it while you're behind white bars. You understand?
Sir.
I'm going to give you a lawyer today, and I want you to get back in high school and get your damn diploma. You will never get anywhere in your life if you don't at least have that. I will help you every way I can, but if you try to toy with me, I'm telling you now, I promise you I'm going to light you up. You understand?
Sir.
Let's get him a lawyer, please. No drugs, no alcohol, no weapons, no hanging out with these people. And I'm going to bring you back in 2 weeks, and I want to see what you've done to at least register to get your GED. If you don't, I'm going to put you over on my knee and I'm going to spank you with a ton of jail time. You understand?
Sir.
Your mom may not be around, but now I am, and I'm going to treat you like a. Come on. Come on, Stephen.
Prolonged conditions or state?
No, it's with them because I'm going to monitor and make sure he's not using.
Okay, got it. Go ahead and sign for your.
Hey, so a 2-week reset to see what we're going to do. Yeah, for sure.
Clark? Come on up, please. Judge, page 9. Circle back.
You ever watch that movie Stand and Deliver?
No, Judge. Never heard of it.
What is this, calculas? You need to watch that movie. Dude reminds me of Stand and Deliver.
Okay.
Okay.
Clark?
Mr. Clark.
You're the stepmother?
Yes.
How old are you, man?
36. I'm sorry, I wasn't.
It's okay. My concern is, are you familiar with what's going on with Mr. Clark? What his criminal history has been, what's been happening, and now what his new case is? Do you know?
Not so much. I work overnight, but he's been talking about it with his mom and his dad, but
So
I just came to a company to see what's going on.
where's mom and dad?
But they're both at work.
Do you mind reading what happened, please, so that she can get the gist?
Sure. On May 12, 2024, officers on view trespassing at the Sunrise Grocery parking lot, which is in Harris County, Texas. Officers observed there to be a no trespassing sign. Officers observed multiple males run off in different directions who are all loitering at the grocery store. Officers made contact with the defendant, who they observed hang out at the Sunrise Grocery store and evade with the other group of males. Once the defendant was detained, officers smelled an odor of marijuana, found multiple individually wrapped bags of marijuana, a larger bag of marijuana, and a scale. Complainant advised that the defendant had been trespassing on his property for 2 hours prior to officers' arrival and would like to press charges for trespassing.
So he just had 2 cases here. He pled to one, evading arrest. They dismissed the other one not less than a month ago. Now he's allegedly slinging at the neighborhood corner store. Everybody's working. When the cat's away, the mice will play. What do we need to do with Mr. Clark to make sure he's not getting in any more trouble?
You can see Judge Fleischer feels bad for the stepmom, who I don't know how she got the task of coming in to catch this spear, but she did, and he feels bad for her.
Did you graduate from high school?
Yes, sir.
Are you in high school?
Yes, sir.
What do we need to do?
Joe? Probation?
No. He's not. We're not even there yet. I mean, this is just so.
I mean, I talked to them, but, you can only tell them so much because I have a 15-year-old, so it's kind of hard to, tell them what to do or the people they hang around with.
Does he live with you or does he live with them?
He was living with his mother, but now he's living with us. We just rented a house.
So he actively now lives with you.
Yes, sir.
You work,
Yes,
but you work at night.
yes, I'm home during the day.
Okay, so what I'm gonna do is I'm putting an ankle monitor on him so I know that he's not out in the middle of the night.
Okay,
So nothing good happens in the middle of the night, you're not to be out. You understand?
Yes, sir.
And I'm gonna drug test you now, and then I'm gonna drug test you in 30 days. And if I find that weed is in your system, I'm gonna lock you up. You will not get any more PR bonds. You understand?
Yes, sir.
So you'll either graduate clean or you're gonna graduate with me behind bars. We can do this the easy way or we can do this the hard way. You're now at 3 cases within the last couple months. It's over. You understand, Mr. Clark?
Yes, Your Honor.
What else do we need to do to make sure that he's not gonna get in trouble?
um, I've never been in this situation.
It's okay. It's,
I have a lot of kids at home, so, I just talk to them a lot. Probation, that's the only
thing
thing.
is that when you have too much time on your hands, Mr. Clark, you become self-destructive. That's what's happening now. You have way too much time on your hands and do nothing productive. Do you have a job?
Sir.
Then that's what you need to do on your off time. You either go to school or you have to graduate. There's no ifs, ands, or buts about it. In your off time, you need to be working or doing something productive.
Yes, sir.
So I am going to give him a curfew so that he's not out in the middle of the night. I would say probably 9 o'clock, something like that. No dope, no weapons. You pick up a new case. Holy moly, I will spontaneously combust because I'll be so upset. Do you understand?
Yes, sir.
No new cases, no smoking weed, and stay in school. Any more issues, I promise you I'm going to keep you. So he's currently enrolled in school, right?
Yes,
You sure?
something like that. I'm just not sure, because his mom is the one that's in charge of that, but, I have to-
So let's do this. I'm going to give him a lawyer, okay? I'm going to set this case off 2 weeks. When he comes back, I want proof that you're actually enrolled in school. I want to see that you're actually in school
Yes, sir.
and attending. Do you understand?
Yes, sir.
Okay, all right. Yeah, 9 PM to 6 AM. Must full-time in school. No drugs, no alcohol. We will test 30 days from today. No weapons and no hanging around with. Pavel, did he have any co-defendants by chance?
I don't believe anybody.
I'm still thinking about him spontaneously combusting like a Spinal Tap drummer.
was connected, no judge.
And no going back to this corner store. No more slinging. Do you understand?
Yes, sir.
No
Okay.
slinging.
Thank you. I'm going to give him a lawyer today. I will give you my phone number. If he starts acting up with you, let me know and I will straighten him out so that there's no issues. Okay? Okay. Thank you for coming.
This way.
Cesar Eduardo Hernandez.
Yes, Your Honor.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present or questions and any views with the state of Texas. If you cannot afford a lawyer will be going to represent yourself. Okay.
Officers responded to an accident in Harris County, Texas on May 11, 2024. Deputy advised prior to his arrival, he was alerted by dispatch that there was a separate accident which occurred, possibly involving the same vehicle. Wheel witness advised she was in her residence at 3546 St. Williams Lane when she heard a loud crash outside of the residence. Wheel witness viewed the vehicle with major front end damage in her front yard in the grass. The vehicle had struck and damaged her brick mailbox. Defendant was in the driver's seat of the vehicle. Wheel witness from the prior accident stated he heard a car crash from inside his residence and exited his residence and observed the same vehicle which struck his black Ford F-150 that was parked on the street. So 2 accidents. Wheel witness observed defendant in the vehicle. Wheel witness observed a strong odor of alcoholic beverage emitting from his breath as well as red glossy eyes and slurred speech. Wheel witness called 911 when the defendant was leaving. Officers observed a strong odor of alcoholic beverage emitting from the defendant's breath as well as red glossy eyes, slurred speech. Defendant advised he fled the scene of the accident because he was afraid and unsure of what to do. Defendant admitting to consuming 2 shots of Jose Cuervo tequila at the bar. 6 out of 6 HGN walk into a 1-leg stand were attempted and stopped by defendant, who stated he could not perform the test because he was too drunk. DIC red consented to
Drinking Cuervo is the real crime here.
breath 0.148, 0.147.
See if he has any prior to be honest, please.
Okay, we're good.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Yes, Your Honor.
Do you have valid liability insurance in your name?
Yes, Your Honor.
I want proof. You said there were 2 accidents?
Yes, sir.
Right.
No priors.
Any prior criminal history?
None.
Okay. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. You understand? We are going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria, sign a reset. After that, we'll get you to pretrial services, no alcohol, no driving without valid liability insurance in your name. If you do, I will have a contempt hearing. You'll be facing an additional 6 months. Do you understand?
Yes, Your Honor.
You will be signing this affidavit that you promise not to drive without liability insurance in your name.
Yes, Your Honor.
If you like your license, I would get on it quick, because if you don't, you may very well lose that driver license.
Yes, Your Honor.
All right, I will have you come up here, swear to this. After that, we'll get you to Victoria, sign a reset, and then we will get you out of here to hire a lawyer.
Yes, Your Honor.
Come on. All right, that way.
All right, Judge, page 4,
Right.
Bernal.
Uh-oh.
No relation.
Wouldn't that be funny if we charged her with something and just come out the car?
All right, David Michael Bernal. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Please don't say anything.
May 13, 2024, officers were dispatched to a suspect chasing the vehicle call in Harris County, Texas. Witness stated the defendant's car was not moving on the freeway, and as the complainant was driving by the defendant, he began to drive again and hit the complainant's vehicle. The witness stated that the defendant stopped for a moment and then left the scene. So she followed the defendant's vehicle and was able to get a plate of the vehicle, which he believes the vehicle was a gray Honda Civic with an unknown driver. Defendant was located about half a mile away with the same license plate. Defendant stated the car started messing up, but was not involved in an accident and was coming from a birthday, and that he smoked a little weed. The value of the damage is approximated at $4,500 from the complainant.
Mr. Bernal, do you have a Texas driver license?
Yes, sir.
For this license, please. Sure. You have valid liability insurance in your name,
Not right now, not at this moment.
and you're not allowed to drive. You'll be signing an affidavit with me today, promising me that you're not going to drive. You may not drive until you prove it to us that you actually have insurance in your name. If you do, I will have a contempt hearing. You'll be facing 6 months in jail every time you drive. You understand?
Yes, sir.
We will reset your case to give you time to hire a lawyer, and then we'll see you back in a month. All right, I'll have you come up here, swear to this. After that, I'll have you sign a reset, and then we'll get you out of here, sir. When you come back, please have a lawyer. Okay. So, because I think they're all waiting for you.
All right, Judge, page 20, Holland.
How many more?
Sorry, one
Get them done.
Yeah.
more.
Oh, he's one, man. Get it done, Colin. All right.
Nicholas Holland. Mr. Holland, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Please don't say anything. Okay.
May 11, 2024, officers were dispatched to Little Woodrose in Harris County, Texas in regards to a minor accident. An off-duty Harris County Sheriff's officer advised that there was a driver who caused a minor accident in the parking lot and was attempting to flee. Defendant admitted to driving and accidentally hit the other vehicle in the parking lot. Defendant admitted to drinking 1 and 2 beers. SFSTs were rejected. Officer observed defendant to have glossy eyes, slurred speech, odor, alcohol emitting from his breath. Wheel witness stated he saw the defendant driving and clearly saw that defendant got out of the vehicle. DIC read, rejected the specimen, blood warrant was executed. The phlebotomist was unable to draw the blood due to Holland becoming upset. Officer had to detain Holland for the blood to be drawn and then had to lay him on the bed. Phlebotomist swabbed Holland's left forearm with iodine to sterilize the area. And that's it for PC, Judge. He does have a DWI from Galveston, December 20th, 2023, with an unknown disposition. So I'm thinking he's still on bond, but I'm not really too sure about it.
Okay, Mr. Holland, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
I did, but I'm not sure now with the refusal.
Sure.
Have valid liability insurance
Yes, sir.
in your name?
Yes, sir.
I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. You will not get any more car bones.
Sir.
I'm also ordering you not to consume alcohol or illegal drugs.
He's not eligible, Your Honor.
Okay, you don't have a license. You're not allowed to drive. You will be signing an affidavit with me today. I swear if you drive, I will have a contempt hearing. I don't care if Mother Teresa needs to go to church, a hospital. You drive, I will have a contempt hearing. You'll be facing 6 months in jail every single time you drive. Do you understand?
Actually, the suspension was since March 29th.
It was since March 29th.
Yes, till September 24th, 2024. So you have not been eligible due to ALR suspension since March 29th, 2024.
So he does have another one then.
Yes.
Right. I would be very careful, sir. If you have an open case, wherever it may be, they will revoke that bond, issue a new warrant. So it would behoove you to get a lawyer as quick as you can because you may have another warrant coming any minute. I'll have you come up here, swear to us that you're not going to drive. I'll get you to Victoria to sign a reset. I am ordering you now to obtain a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You understand? You consume alcohol, I will keep you with me. And if you can't stop, I will put you in a rehab facility to ensure this. I'm going to do everything in my power to protect the people of public, to protect Harris County. And if that means locking you up and making your bond extremely high, I'll do it in a heartbeat, Mr. Holland. So don't force my hand. All right, come on.
Well, there you have it. There you have it. He's previously ordered not to drive Mother Teresa to church. And now apparently the hospital's also off limits. He's also prohibited any slinging and threatened to spontaneously combust. Yeah, well, he also prohibited any P. Diddy type activity. Oh, good times out of Harris County. Thank y'all for coming out. I appreciate it. I'll see y'all soon.